Welcome to all. This is our Shook, Hardy, and Bacon discussion of force majeure and COVID-19, a primer on potential business implications. Initially, we hope you are safe and well, and we appreciate you so much as our clients and friends for joining us in connection with our webinar addressing these issues. My name is Bill Martucci, and I'm fortunate to serve as the moderator today in connection with these issues. With us to lead our discussion are Lynn Murray and Tom Sullivan. Lynn Murray is our managing partner of our Chicago office, where her vast practice includes a great deal of focus on business and commercial litigation matters. Lynn is an accomplished trial lawyer and has been recognized as such by being a member in the American College of Trial Lawyers. Our clients consistently rave about Lynn and her strategic insights. We also have Tom Sullivan, our fellow partner in the Philadelphia office. Like Lynn, Tom is an accomplished trial lawyer who is quite well versed in connection with business litigation matters, including disputes regarding collaboration and development agreements, supply agreements, and post-acquisition disputes. He has been recognized by L.L.P Life Sciences as an all-star strategist and counselor. We're so thankful to be with you today. Our discussion will begin with a few brief comments by Tom, and then Tom and Lynn will take us through a variety of considerations from there, and we'll wrap up with questions and answers. Tom?
Thanks, Bill. Thank you, Lynn. Hi, everybody. This is a truly unprecedented and challenging time, and our goal today is to provide you with an overview of some of the basic contract doctrines that may be implicated in your business relationships. And we recognize we've got a lot of people on the phone, a lot of people from different backgrounds, from different industries, including hospitality, transportation, tech, retail, healthcare, and life sciences, just to name a few. And everybody's coming at this with a little bit different experience. So what I wanted to do just at the outset here quickly is to give a little bit of context for what we're going to talk about today. First, in the first half of the presentation, we're going to address contract-based provisions that may give you or your counterparty a reason for excused performance. And we're going to begin with force majeure provisions. We will talk quickly about material adverse change provisions, and then we are going to talk about common law provisions, including common law doctrines like impracticability and frustration of purpose. And we're also going to cover Ucc. So with that, I'm going to turn the initial part of this over to Lynn to begin the discussion about force majeure.
So what we've been finding over the last week or 10 days as we work with people is that the industries tend to fall into three different categories. Some that are most directly affected by the results of the epidemic, hotel, airline, hospitality. Those are the groups that are most likely to want to declare force majeure, but there are exceptions there. Even within that group, there will be individual circumstances where those folks will want to say, no, you should not cancel a conference in early May, and things of that nature. In the middle are a mixed group where our clients and industries sometimes they would like to declare force majeure, sometimes they would like to resist force majeure, and then you have companies like food manufacturers who are running flat out right now and want to make sure that their mission critical supply contracts are holding up and that they're not being subjected to force majeure. So just as people are coming at this with a different level of knowledge, they're coming at this from different positions. So the force majeure is a commercial contract term. Sometimes it's used very loosely, and companies will say, I'm declaring force majeure, even though they don't have a contract. But the true definition of force majeure is a commercial contract term, and the terms of the contract determine the availability and scope, and those are really three things: listed events, catch-all clauses, and impact on performance. And to give you a visual of what that looks like, this is a force majeure clause from a case. Impact on performance is that language caused by. Sometimes it's due to, sometimes it's subject to, but what's the language? What has to actually have been the impact on performance to apply a force majeure clause. Then you have typically listed events. Here we have starting with war, ending with terrorism. Epidemic is not in the listed events in this clause. And you have a catch-all clause often, other similar events. Sometimes it says other similar events or dissimilar events. So those three things, what's the causation language, what are the listed events, what does your catch-all clause look like, those will be very important in analyzing whether or not you are able to declare force majeure or alternatively able to push back if someone's declaring force majeure and you don't want them to. So if we go on and look at that in a little bit more detail, this is the issue of the listed events and the catch-all clauses. Another example of a force majeure clause up at the top, which does specifically list epidemics and quarantine restrictions. But if you don't have epidemics in your list of items, the force majeure is then going to depend on the nature of the catch-all clause. Sometimes the catch-all clause will require similarity of listed events, and what we've seen as it relates to an epidemic is act of God, government regulations, labor disturbances, civic commotion, a new one, industrial disruption. For anyone who hasn't recently examined what an act of God is, it is something that is caused only by natural forces and not by human intervention. You can see that most of the time, act of God, an epidemic like this would be an act of God. I can anticipate that there will be arguments that certain forms of human intervention or lack of human intervention actually made this not an act of God. The item right below that is another form of catch-all clause that says events similar or dissimilar beyond your reasonable control. When you have that kind of language, you have a pretty broad force majeure clause, essentially a force majeure clause that just says if there's something beyond your control, that can be a force majeure event. And then you have some clauses that expressly include or exclude commercial considerations. What you often see there is something like commercial hardship is not a force majeure event. Or alternatively, commercial hardship can be actually within the list of items. So it depends on what your clause actually looks like. Now, most clauses that we see apply to both buyers and sellers, and most of them apply equally to buyers and sellers, but you will see some force majeure clauses that apply only to a seller. And if you're a buyer and you would like to declare force majeure, what you need to do is to go to the second half of this presentation, which is the common law doctrines and the UCC to a lesser extent for a buyer. Others have different terms for buyers and sellers, and we typically see this when it's a terms and conditions question, when either a seller has their terms and conditions accepted or a buyer has their terms and conditions accepted. What we'll see is that the force majeure clause is pretty one-sided. If you accept the seller's T&C, then the seller would have a broad right to declare force majeure, and the buyers would have a very narrow right to declare force majeure. This area, the impact on performance, this seems likely to be the biggest issue in dispute between parties. Up at the top here, we've listed some likely virus-related problems. You have probably seen these and more as you're struggling to deal with your business issues. But this is at least the major things that are likely to happen with the virus. So those things do actually lead to significant economic hardship. But many cases out there hold that economic hardship alone is not sufficient based on the language in their provisions. And so what you're going to need to do in some cases is say, this is an epidemic, it causes a workforce reduction, it causes government restrictions. Those things are the cause of the force majeure event and the reason why I can't comply with my performance obligations. Here again, the language of your clause is going to be very important because how closely the event needs to be linked to your performance and your inability to perform is going to be affected by the clause. In particular, if you have language that says subject to the force, your performance is subject to the force majeure event. That's fairly loose language. What does that mean exactly? That gives you a fairly broad right to declare force majeure. If it has to be due to or caused by the event, that starts to tighten it up a little bit. And then you look down here at the bottom, if your performance has to be absolutely prevented by the force majeure event, that's one thing, but just performance diminished by the force majeure event, that's another thing. So just a few practical points. you'll see case law out there saying that force majeure clauses will be narrowly construed. Courts actually don't like to enforce force majeure clauses. They like to see contracts performed. A very important point is that a force majeure event can be a double-edged sword. You end up, you may have issues with your suppliers, and within the suppliers, you may have certain mission-critical contracts that you want to go forward, and you may have other contracts that you feel shouldn't go forward. And then on the other hand, you're going to be dealing with customers, and you're going to have to look at the force majeure positions you're taking and make sure that, as we would say, they're reasonably reconciled. It may not be possible to reconcile all the force majeure provisions, but recognize that you're dealing with it from both a buy and a sell slide. So, as we've said here, you analyze the contract language closely, look at the choice of law, and I'll turn it over to Tom for a few more practical points.
Thank you, Lynn. As Lynn said, the real starting point for this analysis has to be the language of the contract and has to be the language of that force majeure provision. And as well, it's really important to understand the jurisdiction you're in and understand the impact of declaring a force majeure event. And whether a force majeure declaration is appropriate in a particular circumstance is really going to depend heavily on the language of the actual contract. It's important to analyze that closely and to try and get that right, because if you declare a force majeure event, the other party may seek assurance of your performance and may be able to claim a breach if that analysis is incorrect. And in complying, in doing this analysis, it's especially important to comply with the procedural requirements in a contract with respect to prompt notice, with respect to communications, and also with respect to understanding what your obligations are in terms of a duty to mitigate and to allocate performance. And we're going to talk about allocation of performance as we go along, but the real important point to keep in mind there that generally your allocation of performance, assuming that you can perform only partially, is to make sure it's fair and reasonable and meets the standards of commercial reasonableness, meaning it's got to be a fair allocation of performance to your customers, for example, if you're, say, an intermediate supplier. So we've covered so far force majeure provisions. There's one other type of provision you may find in your contracts. Again, this would be in your written agreements. And typically this kind of provision, called the material adverse change clause, is found in commercial contracts like merger and acquisition agreements, asset purchase agreements, those types of agreements, for the sale or acquisition of a business or part of a business. And again, the title of it is a material adverse change clause. The idea is very similar, where the party's performance may be excused under the contract if there is a material change in the business operations or financial condition of a company. We've cited some case law here that are these are some of the main cases in the area of material adverse changes. Some of the types of changes that courts have considered are changes in business practices, loss of key personnel, failure to meet sales forecasts, damage to the value of a company, such as a loss in profits. This is probably a less common provision than a force majeure provision, but in this context, in the time that we're in, it is important to take a look at this kind of provision as well. And again, the really important thing is to closely analyze the language. With that, we're going to turn now to a discussion of some important UCC requirements, and this is going to take us sort of outside the context of the actual written agreement and with a focus on the common law. So Lynn, I'm going to turn it back over to you.
Tom, before we go there, I wanted to answer one question that's coming in and go back to an earlier slide. Someone asked, does the force majeure event have to be the sole sole event causing it. And so we go back here to the impact on performance. An example that you see out there, obviously oil prices are having a major impact on the economy as well as the epidemic. I think if you look down here at the bottom and if your performance has to be prevented by the force majeure event, if you have that kind of very strict language, you will probably get a lot closer to it having to be the sole causative event rather than just subject to the event. So that's where when you sort of try to distinguish between the language of your clause and figure out whether you fit into a narrow bucket, kind of a medium bucket, or a broad bucket, that's the kind of question you're trying to answer. And with that, I will go to the UCC. And
Lynn, this is Bill. I might just mention that this second segment obviously is going to touch the UCC and then look at common law impracticality as well as frustration of purpose. So thanks so much.
Sure. Let me get here to move ahead. And the UCC is very important here, particularly if you don't have a force majeure clause. There's a real question of whether a force majeure clause and the UCC impracticability doctrine can live together. Typically not. So the UCC is going to come into place where you don't have a force majeure clause. Interestingly enough, that's not necessarily bad news, particularly if you are a supplier who wants to declare force majeure, because the UCC standard is impracticability rather than impossibility or prevented entirely. If you're in the world of the UCC, you need to be a seller with one exception, and that is there's a comment in the UCC, comment 9. If you're a buyer and you want to use that, that's the place to go to try to say there's a little application to a buyer. And the UCC does not apply to a seller if it's contracted for greater obligations. In other words, if it has a force majeure clause that is narrower than what the UCC would give you. This language sounds pretty good and pretty interesting, and people are not dismayed when they end up under the UCC and they want to declare force majeure. The problem is that it's been reviewed very, very narrowly in some very significant cases. The closest kinds of cases that we have to what's happening right now are the recession, the OPEC oil crisis, the closing of the Suez Canal, forcing ships to go around Africa to get its deliveries. In each of those cases, the courts have said that it's not commercially impracticable because it could be performed. So good language, tough facts when you get to the cases. It's very unclear whether or not finally with this particular widespread problem we'll get a different result. Tom, you want to carry on?
Sure. So Bill mentioned that in addition to the UCC, there are also available common law doctrines that any party should look at with regard to excusing performance. The first doctrine is the doctrine of impracticability. And the impracticability doctrine arose out of the common law that began a long time ago in England with cases where performance was literally impossible. For those of you who went to law school, you may remember the Taylor versus Caldwell case. There, a defendant promised to make a theater available to the plaintiff for 4 shows. The theater burned down. The plaintiff then sued for costs, the costs of getting ready for those 4 shows. But the court found there that the performance was excused because obviously the theater did not exist anymore. Well, that's now been cabined into the doctrine of impracticability that is contained in the Restatement of Contracts. And there the idea is if performance is impracticable without fault by an event that was not foreseen and it was a basic assumption of the contract, generally that performance can be excused. So if you look at your force majeure provision and that doesn't give you or give your counterparty a way to excuse performance and you don't have one and you don't have anything else, you can look to the law of impracticability and that may apply in this situation. Again, key point here is that this is highly jurisdiction specific And as Lynn mentioned, this doctrine may not be available if you have a force majeure provision in your agreement. The key concepts here, though, are the performance must be impracticable, the party declaring it must be without fault, and generally it must not be foreseeable. And those are the key elements. The next common law doctrine that may be available is a little bit different than impracticability. It's different than force majeure, and it's called frustration of purpose. And the difference and the key with frustration of purpose and what makes this a different kind of doctrine is here, the point isn't that the performance is not impossible. The point isn't that the performance is not impracticable. Here, the situation is that the reason for the agreement, the whole purpose for the agreement, no longer exists. And again, for those of you who went to law school, the key case in this area back over 100 years ago now was Krell versus Henry, and this was a case in which the plaintiff had rented an apartment. The defendant paid the plaintiff to go watch a parade for the coronation of the king in that apartment. The parade then got canceled, so the defendant's reason for renting the apartment no longer existed. And nevertheless, the plaintiff tried to recover money from the defendant, saying that the defendant still could have gone and sat in the apartment, but the defendant's position was, look, there is no parade. My whole reason, my whole purpose for entering into this contract no longer exists. And the court agreed with the defendant in that case and excused the performance on the grounds that both parties there understood that the whole purpose of renting the apartment was to watch the parade, and because it was canceled, that no longer existed. So here, it's not, in this doctrine, it's not just that it's not that performance is impossible, it's that the whole purpose of the agreement no longer makes sense. And both parties typically, again, make sure you check the case law in your jurisdictions, but the general law here is that both parties must appreciate that, must appreciate the purpose for which the agreement was entered. It can't just be a unilateral subjective view typically of what the purpose of the agreement is. So I think that brings us to the end.
I think it does, Tom and Lynn. Really nice job. I know we have a number of questions. Let me start out with one or two very straightforward questions in terms of easy to ask and lots of guidance to give. And then Tom and Lynn, feel free to pick up questions from the Q&A area as you are most comfortable. But I do want to commend you because we wanted to keep this informal and relatively brief, and you've really done that well. So thank you so much. Tom and Lynn, here's a question that focuses a little bit more on that practical guidance aspect. And in that regard, how significant is it to keep good records, to document, memorialize the kinds of things you're concerned about, including phone calls? Is that something that's rather vital? And to the extent it is, what guidance do you have in that regard to build your factual context?
Sure, I'm happy to take that one, Bill. I think, good practical hygiene here, so to speak, is really important. A lot of these cases, when you read them, it's amazing the degree to which they turn on very specific facts. They're highly fact-based, and for that reason, I think it's very important to build a clean, clear record before trying to assert force majeure. And obviously, if you're on the party of a receiving end of such a notice, you want to make sure that you develop your record. Likewise, we're in a time, in a very intense time where there are likely to be a lot of phone calls and emails and those kinds of things going back and forth between suppliers, and very important to maintain those records. And also, if you're a lawyer, to keep in mind the boundaries and the scope of the attorney-client privilege in this context.
Very good. Lynn, let's say that a given company is operating pretty well, but what kinds of contingency planning should they take into play in light of COVID-19?
I think the main thing you have to do is you have to make sure that you know what your force majeure clauses contain, and particularly the mission critical force majeure clauses. You need to make sure that they are laid out. We've been charting out for various clients what the force majeure clauses say, who you give notice to, be able to react quickly, because this is exactly the kind of thing that it's going to hit. It's going to hit big. It's going to hit within 24, 48 hours, and you need to know what's out there.
Lynn, let me ask you something that's a little bit of a lead on to that, and that is, let's say that the clauses provide, quote, caused by an event outside the party's control, end quote. Let's say it's as broad as that. How would you interpret that kind of clause in light of the considerations we've talked about today?
In some ways, that is the broadest form of clause. You don't have to have a list. You don't have to have a catch-all for that kind of a clause. It just has to be an event outside your control. As we discussed earlier, though, the fact that it says caused by is where you're potentially going to get into a dispute. What does it mean for this epidemic to cause something? And if what it causes is, for example, an anticipated loss of demand, it's caused something, is that under the law of your jurisdiction going to be enough? So you still have the tricky caused by language, but you've got sort of an open playing field if you want to declare force majeure, as opposed to fighting back against it on the list of events. And Bill, I can just pick up a few of the questions that I'm seeing here too. There's a number of questions on services contracts and the UCC. The UCC, unfortunately, does not apply to services contract unless you can put it into the primarily goods category. So you don't have the commercial impracticability of the UCC for those kinds of contracts, but you would have the doctrines that Tom is describing, the common law doctrines. Another question was whether or not you can use those common law doctrines if you have a force majeure clause. And I think Tom had a slide earlier which has some jurisdictions allow impracticability, common law, to be argued as an alternative to force majeure, and others do not. I'll tell you, in general, the case law on force majeure is very old, often. It's very inconsistent, often. The terms are used quite loosely. So I think you are going to find, we would love to be able to tell you here's the bright line test on a number of things, but you are going to find that they're going to go jurisdiction by jurisdiction.
Really
and Lynn, on that point, on that point, the jurisdictional analysis here is not just important in the legal sense of identifying the relevant law. It's also going to be very important because of the varied actions taken by local counties, by states, and the guidance that exists in some of the government documents. Those are those types of local facts or regional specific facts could very well matter in the analysis of whether a force majeure or some other doctrine applies.
And Tom, let me throw a question I just saw to you. If the contract has a force majeure provision that doesn't include pandemic or it's just not going to apply for some reason, can you also use frustration of purpose?
I think, obviously that's going to depend on the circumstances. It's also going to depend on what the purpose, whether both parties appreciated what the purpose of the agreement was. As a threshold matter, it will depend legally on whether that jurisdiction allows common law doctrines to apply even when there is a force majeure provision. So those are some of the critical considerations, but it is possible that you could have an instance where the virus has undermined the purpose of an agreement, assuming both parties shared that in mind. I mean, that's the default rule, is that both parties must have that purpose in mind, and it must better, the case law suggests, if that purpose is articulated and expressed in the agreement.
So, Tom, if it's not expressed in the agreement, would contemporaneous, extraneous kind of communications be helpful, or would those not be permitted?
They may be permitted depending on whether you can generate, I think, an argument over, in potentially ambiguous terms, and there are the parole evidence rules. typically courts are going to try to resolve these issues as best they can based on the language in the actual agreement itself.
Bill, if I could address one more question, and then we should probably wrap it up to respect people's time.
Very good. Sounds great, Lynn.
There's a question about what if you have, and I've seen these, force majeure clauses that require continuing payment. Could you actually use one of the common law doctrines to say, well, no, we don't have to continue to pay? It's, again, applies to this. We've got the contract. We've got the common law doctrine. My view, not based on research of the case law, I'll put that caveat, would be that would be perhaps a bridge too far, in the sense that you would be directly contradicting the contractual term rather than trying to meld and reconcile that with the common law. So obviously there could be cases out there that we haven't seen yet that would give you an argument, but that's a quick view.
Well, wonderful comments, Lynn and Tom. Let's close out with one question for Tom, and then any comment that Lynn and Tom wish to make as we wrap up. We wanted to keep this brief, so we appreciate everyone being with us. Tom, one real practical issue that often comes up, to state the obvious in this context of litigation and potential litigation, is the attorney-client privilege and work product. And what thoughts do you have about, perhaps I'm corporate counsel, but perhaps I'm a business advisor as well as a legal advisor? How does that impact privilege?
Sure. Well, the general rule, as a lot of people know, Bill, is that communications that are made in your capacity as a legal advisor would be subject to the privilege, and communications that are made in your capacity as a member of the business team would not be. And then, of course, there are communications that sometimes fall within that gray area where a person may be operating in both capacities. Here, I think the practical guidance is be very mindful of what you write, but do make a clear record, and make sure those communications are limited to appropriate team members.
Thanks, Tom. Lynn, any closing comment as we go to you and then Tom, and then we'll say goodbye to our clients and friends?
I have an important closing comment responding to numerous questions, which are, yes, you will get a copy of the slides.
Very good. Tom, any closing comment?
The only other, one other closing comment, I was just trying to track through some of the questions there quickly. The other thing here, I think, is, again, this goes to the really fact-specific nature of this analysis, is that timing matters. When did the performance become, impracticable, impossible? When did it become subject to the force majeure? And that also dovetails with the point about when certain government guidance came out, when certain things may have closed down, when certain things happened. And that just all funnels back into making sure you build a clear record.
Well, thanks so much, Lynn and Tom, and thank you, our clients and friends. We care about you a lot. As we've noted, we all know it's an unprecedented time. We thought this topic, as we discussed it within our commercial litigation group, might be particularly helpful. We hope it has been. We hope to hear from you if you have questions or concerns, and please stay well. This concludes our program. Thank you so much.